Before I go to Joe and Sean to see if they have anything to add, I want to pick on you again, David, and that is the Army Field Manual has a standard that's often referred to as the golden rule that impresses me tremendously in terms of trying to translate all this legalese into language that a soldier interrogator might understand. Would you tell us a little bit about this golden rule principle?
Well, actually, it's actually more of a teaching technique than anything else. When we would talk to trained military interrogators at Fort Huachuca, if the tactic or technique that you're thinking about would be applied to your own personnel, would you think that it was a violation of the law, or is it something that you would not want applied to your personnel? And that's a very simple question, but when you ask that question, you get a pretty positive and valid response every time.
Yeah, it's teach. I remember as an infantry recon platoon leader back in the 60s being told at 11 a.m. on a Saturday morning that after lunch you're going to teach the law of war component. This was long before I went to law school. And I said, what? And they handed me this file, and as I ate a sandwich, I sped through it, and then I tried to get up and teach it. But let's say I didn't do a very good job of it, and I was the one that was my judgment. I can only imagine what the poor kids that had to listen to it said, but when you put it in these terms, most of us are raised in one of the main religions where we talk about this basic principle of don't do to others things that you would not want done to you, or do unto others, and so forth. And it's brilliantly done there, I think. Joe, do you want to add to that?
I agree very, very strongly with David, and just want to key off it in this respect. The significance of the observation that he makes, it seems to me, is that there is a pre-existing legal regime that contemplates the protection of people captured, however it is you designate them, and however it is they come into your custody, and whatever the character of the conflict is. We seem to behave as though terrorism is something that landed like a spaceship on 9/11, and that there was no prior legal or military contemplation of its significance prior to that point. And that's just legally incorrect. As a doctrinal matter, it was simply incorrect. And what emerges, and what we see concretely and repeatedly, is the determination by the architects of the administration's detention policy to displace that legal regime. And so in that respect, the law drove, or rather the policy drove out the law. We sometimes talk as though the law were predominant, as though it were a matter of identifying what the law allowed, and that this was a very difficult and complex question because there wasn't an existing set of rules for the law. That's just not true. There was an existing set of rules. It was clear. It remains clear. What happened instead, however, as my friend Philippe makes plain, is that there was a policy determination to displace the law. What you see, therefore, is the law doesn't shape the policy. The policy shapes the law. The law became an instrument of this misguided policy. So when we argue about, does the law allow this? Torture is such an ugly word. It gets us into these circular questions about the meaning of torture. That is a wholly vacuous and unnecessary argument. It's an important argument, but it's ultimately unsatisfying because it doesn't get at the reality of what took place. What took place is a policy judgment that said we need to displace the pre-existing legal regime that David talked about. And what we should focus our attention on is whether it was prudent, whether and to what extent it was a good policy judgment to displace that legal regime. And if you get at that question, you will get, and I think that what we could all establish is that that was a mistake for a variety of reasons, which I hope to expand on. You would then remove the pressure on that regime and allow it to restore it to the place that it occupied prior to 9/11, a place that, in my estimation, it ought to continue to occupy.
Bob, and we're going to give Sean a chance here, but let me just say that even though it was a policy decision, it was a policy decision that the administration thought needed to have a legal basis.
Yes.
And the key to the entire thing here is the declaration of these individuals as unlawful enemy combatants. Enemy combatant is a term of art to which traditionally all the rights of POWs were afforded. But unlawful enemy combatant is something else. And they went to great lengths, and we could go through the legal analysis. We don't have time to find that neither Al-Qaeda nor Taliban personnel were in fact lawful combatants. They were unlawful enemy combatants. But then once having determined that they were unlawful enemy combatants and the Geneva Conventions didn't apply, then it was as if nothing applied.
Right.
And the only legal analysis that was connected was if what we want to do would violate the torture statute, 18 U.S.C. 2340A, which is the implementation of the Convention Against Torture. That was the only legal analysis that was conducted, leaving completely aside the fact that there were tremendous numbers of other international norms out there that afforded rights and protections to these individuals. But it was very important to the administration to reach the determination that they were unlawful enemy combatants, because they thought once they got to that point, they were home free. The Geneva Conventions were simply being applied as a matter of policy, vice law, and policy could be changed. And folks, this is how we're going to change the policy.
David, just a quick comment, because I think you may have misspoke. You said the decision that once we decided the Geneva Conventions didn't apply, you mean the formal provisions, and you're not excluding Common Article 3, which clearly does apply, is
Well, in the eyes of the administration, certainly they thought none of the Geneva Conventions.
Yeah, the argument there was it's not a conflict of an international character, or it is a conflict of an international character, and thus Article 3 doesn't apply because there are several states involved in the conflict. In other words, the fact there are no states on both sides of the conflict.
This was much earlier on, Bob.
Yeah.
This was prior to Hamdan.
Yeah,
when the Supreme
yeah,
Court
that's
said-
what it, yeah. Sean, go ahead.
Well, just so that there's no lack of clarity here,